this is the second video of 3 videos that I've recorded about the anatomy of a lawsuit, a civil lawsuit. So in this second part of virtually all civil lawsuits, the various sides of the lawsuit, and there's typically 2. There's typically a plaintiff and defendant, but sometimes there are others, which is a little too complicated for this video. In any event, those people involved in the lawsuit who are called parties are given various methods by court rules to get information from the other side or from witnesses or financial institutions or perhaps medical records. Now, there are a multitude of ways that we get information, but there are 3 primary ways that happen in almost all lawsuits. The first is written questions can be sent to the other side. They are called interrogatories. Our rules say that you can send up to 30 questions. They need to be answered in writing and signed under oath by the other side. In addition to that, we can send a request for production of documents to the other side. We can ask them to give us appropriate documentation. This could be something like a copy of medical records, a copy of bank records, that kind of thing. Typically, we see only 1 request for production of documents, but the rules do allow for more than 1. The final most common way we get information is in a process called a deposition. That is live testimony taken before a court reporter. Sometimes it's videotaped. Typically it's done in one of the lawyer's offices. Whoever is giving the testimony is sworn to tell the truth, just like court. And the lawyers who are present, and if people are there without a lawyer, they have the right to, get to ask questions that are relevant to the lawsuit. Now, there are other discovery methods, and that, by the way, is the general term for all of these basic methods for getting information. We call it discovery. It's a noun. We sometimes talk about doing discovery, getting discovery, etc. This second part of any lawsuit is actually voluntary on everybody's parts. You don't have to do it. Pretty much any lawyer will do it. And it is the part of any litigation where lawyers can spend an awful lot of time. I would say, unless it's a long trial, probably most time is involved in the discovery process.